Hey y'all, Rob here with ATX.LEGAL, and this is one of the more important videos in the guide, which is the outcome of the criminal case. This is what everyone wants to know. What's going to happen? Am I going to get a conviction? What's going to be in my criminal record? Here we go. And we're going to start from the best case scenario all the way to the worst, and the best case scenario is a dismissal. Is it rare? Kind of, but it does happen. If the police have botched their investigation in some way, if there's very little evidence for a DWI, if the BAC comes out below 0.08, or if there is no BAC test in this case, a dismissal can be possible. Now, sometimes that's a straight dismissal and that's it. That's the end of the story. Other times they do ask for you to give something and put something on the table, such as doing classes, community service. Sometimes they'll ask for an ignition interlock for a time with no violations, but if you do those steps, they will dismiss the case. And like I said, dismissal is the best possible outcome. You can get your case expunged, and we'll talk about that later, but it'll basically be completely off your record like it never happened. Now, this next outcome still results in a dismissal, so you can get it off your criminal history, but you do have to plead guilty to a lesser charge. And what I'm talking about is like a Class C violation, such as a speeding, blowing through a stop sign, some kind of fine-only Class C violation, and that goes on your driving record. But it's much, much better than a DWI. The DWI can be expunged even if you have pled to a Class C speeding violation or some other traffic violation. And there is another option that results in a dismissal, and this is DWI pretrial diversion. Now, if you've looked at any of my previous videos or previous material on DWI diversion that was before last year, you will see that I did not recommend DWI diversion in almost any circumstance. However, the new county attorney, Delia Garza, has come in and revamped that program, and now it's actually a very good option. You have to apply to get into the program, and they accept Class B misdemeanors or Class A's if the BAC is under 0.2. They don't accept Class A's for a second DWI, and they don't accept whose DWI involves a collision, even if it's a minor collision. And if accepted, the program will last a year, but it can be curtailed down to 6 months if you have no violations on your IID. And that gets me to the second point. You have to voluntarily put an IID in your vehicle for 6 months, have no violations. If you have a violation, you can be kicked out of the program. And the other way to get kicked out of the program would be to have a new DWI charge. But as long as you don't have a new charge and keep a clean IID, in some cases they are adding on community service hours, but as long as you complete all those, your DWI is dismissed and you can have it expunged. Despite the IID as kind of a burdensome condition, it is a very good program, and I recommend it to many of my clients who are eligible. If none of the previous options are available, we'll look at an obstructing a roadway conviction. In these cases, the DWI is dismissed and an obstructing is filed in its place. Now, an obstructing is a Class B misdemeanor, meaning it's more than just a traffic ticket. And in addition to that, a lot of people will look at your criminal history, see an obstructing, and they'll kind of understand what happened because it's kind of a legal fiction for a DWI. So even though it does result in the dismissal of the DWI and your DWI can be expunged, the obstructing will still be on your record and people might know it's a DWI. Still, it's better to have that obstructing than a DWI for a lot of reasons. Now, if none of those are available, you're usually still not looking at jail time. There are probation and deferred adjudication options. With a deferred adjudication, your DWI can be sealed. However, there are very limited DWIs that will be eligible for deferred adjudication, and you would need to sometimes voluntarily put on an ignition interlock device in order to get the deferred adjudication, which would allow you to seal it. If you're thinking about a deferred versus a probation and you are eligible for it, talk to your attorney, really understand the differences because there's a lot of subtleties there as far as which one is better. Probation terms are usually 1 to 2 years. You do need to check in with probation officers, although after COVID, a lot of that is happening by phone or sometimes by Zoom. There are monthly probation fees, and oftentimes an ignition interlock device will be part of your probation for either half the term or the full term. And for very severe DWIs, the prosecution might ask for days as a condition of probation. It's called days ACOP. And what that means is you would serve a certain amount of days in custody, and when you get released, you would still be on probation. So it's kind of a double whammy. You're doing the probation and the days in jail. So that's really reserved for more severe DWIs, Class A with extremely high BAC, maybe it's a second DWI, a lot of factors for them to ask for you to spend time in jail in addition to your probation. And lastly, I do want to touch on people who just want to take that conviction, serve their time in jail, not be on probation. Sometimes that can be a possibility. If you just want to get it out of the way and knock it out. Jail time is usually not forced on people. It can be an option, and it's something to think about. Now, another thing to consider is the SUPERFINE, which was enacted by the Texas government a couple of years ago. When they removed the surcharges program, they replaced it with this crazy fine that can go from $3,000 to $6,000, depending on if it's a Class A, Class B, second time DWI, etc. So the thing to note about that is it only occurs with a final conviction. So many judges read that law and say that a probation is not a final conviction, and they'll axe that fine. But it is at the discretion of the judge, so you'll want to talk about it with your attorney before agreeing to any plea offer. Another thing to consider is a jail term is definitely a final conviction. Judges can't even get around that. The only way I've seen a fine waived if you do take the jail time is if the judge can find you indigent, and that means you're not able to afford it. So some judges will take that very liberally and find very many people indigent. Others are not willing to do that. Again, talk to your attorney before you do the plea so that you know what to expect. And none of this is legal advice. It's all educational purposes only. If you have any more questions, you can check out the guide below or check out our other videos. And you can always visit us at ATX.LEGAL.